Tonight we're getting some more insight into what the jurors in the Tenzing trial were actually thinking before they were selected. Anjanette Levy spent the night going through those questionnaires. Joins us with what they feared. Anjanette?
Well, Rob, lawyers for some media outlets actually had to go to court to argue for the release of these questionnaires. The judge didn't want to release them, and the jurors didn't want them out either.
400 pages of questionnaires were released, the jurors' personal information redacted. Jurors had to answer about 200 questions.
There's nothing in there to surprise. The things that you're looking for are a juror who is open to considering the evidence and has not prejudged one way or the other.
The questionnaires show some of the Tenzing jurors feared riots or civil unrest if Tenzing was found not guilty. One juror wrote, "No matter the verdict, I believe the public would react either way because it's a very sensitive matter." Others marked they feared for their personal safety. The prosecution says it will try Tenzing a second time, but in a strange twist, the prosecutor is asking that the second trial be moved to another county because of the jurors' fears.
It's very rare to see, in my experience of over, 25 years, the state asking for a change of venue.
Defense attorney Jay Clark represented Ryan Winmer, the Warren County man found guilty of killing his wife. In Winmer's third trial, the state also asked for a change of venue, but that request was denied. Typically, a change of venue is requested by a defendant because he or she feels they cannot get a fair trial.
Really, there's nowhere in the Constitution that says the state's entitled to a fair trial. They have all the other advantages. They have the manpower, the scientific, the resources behind that, everything. The Constitution protects individuals, not the state.
Now we'll have to wait and see what Judge Gibbs decides on moving the trial, but it really could be a tough sell given it's the state's request, and Ray Tenzing made the same request before his first trial, and his request was denied. And really these are very interesting questionnaires to read through. Nearly 200 questions they had to answer. There were two women, African-American women on the jury. They both said they didn't believe that the justice system was fair, but all of the remaining jurors, who were all white, said they believed the system was fair. And there was actually one juror who said she had some family members, her grandparents, she believed were prejudiced, but that her father wasn't. She was allowed to remain on that jury. She said she didn't have any bad feelings about people of other races.
So let's say again that there's no names, no IDs, there's no
Right.
way for us to know who these jurors are.
Exactly, and that's actually somewhat unusual, at least in the trials I've covered. Usually those become public record. They are public record, those names and places where they work, their addresses are released, but I guess these judges, or the judge and these jurors all said they didn't want this information out there. The jurors expressed some really legitimate fear that you read about in these questionnaires, and they were afraid they might be targeted no matter what the verdict was. So I guess, you know, they went to court, she released redacted versions of them. We'll see if anybody challenges that any further.
Interesting, thanks.